Good afternoon, everyone, and welcome to WA Live Court TV Edition. I am your host, Brian Keith Jackson, and this is going to be the last day of Supreme Court Week here at Woodward Academy. We have on the docket today a new case. The name of the case is called Fisher versus University of Texas. But before we go into that particular case, let me tell you what you're going to see. There were two cases that were argued yesterday in which we ran out of time and didn't give a verdict. So when the Supreme Court justices come in, they're going to give you the verdict for the last two cases, and then we're going to move immediately to the Fisher versus UT case arguments. Now, let me talk to you a little bit about the Court TV and the color commentators we have here in the studio. All right, flanked on my left, I have the former ACLU attorney, Ms. Maggie Berthume, and flanked on my right, I have the former government U.S. attorney, Mr. Bill Batterman. They will serve as our color commentators for today's proceedings, and they're going to preview for us the Fisher versus University of Texas case. All right, counselors, as I understand it, this is what is commonly known as a reverse race discrimination case in which a student was denied admission at the University of Texas. Tell us a little bit about what you think is going to happen in these proceedings.
Absolutely. The issue here comes from a student named Abigail Fisher, who is denied access to the University of Texas, and she believes that was because of her race. She's a white student. And she is arguing that the University of Texas's use of race in the admissions process is unconstitutional under the Equal Protection Clause of the 14th Amendment. The issue before the court today is that they are going to be asked to clarify some of their previous rulings, including in Grutter v. Bollinger, to assess whether the use of race in Texas's system in particular is constitutional. And this will have pretty wide-reaching effects because there are a number of different ways they could rule, and all of them will impact college admissions throughout the country.
Oh, very good. All right, Mr. Batterman, let's talk to you a little bit about the Grutter versus Bollinger case, the precedent for the current case, Fisher versus University of Texas. Tell us a little bit about the history of using race as a factor in admissions in college and universities across America.
Okay, well, this is an issue where the government and the ACLU are in agreement, as well as many business leaders, the military, and a lot of other entities that support the idea of diversity. And in the Grutter decision, the Supreme Court acknowledged that there's an inherent value in providing a diverse student population, and so therefore refused to strike down race-based admissions. They did, however, say that those admissions process can't be based on quotas. They can't be mechanical. They can only acknowledge the value of diversity but not mandate any particular numbers. And so in this case, the court will have to decide whether it wants to put teeth into that decision and say that the consideration of race by the University of Texas in the second part of their admissions decision. So the first part, if you're in the top 10%, you get in. In the second part, if you aren't in the top 10%, your race can be considered a factor. They could decide that their Grutter decision needs to be clarified to exclude that racial consideration, and that's the issue before the court.
All right, so counsel, at the end of the day, what do you think is going to happen? Do you think that the Supreme Court is going to allow race to be a factor in the college admission process, or do you think this is the beginning, the death knell, so to speak, of affirmative action?
Good question. One thing to note is that we're dealing with an 8-member court today. Justice Kagan has recused herself in the actual Supreme Court proceedings because she was involved in earlier litigation with the Justice Department. So really the best that Texas can hope for is a 4-4 decision with probably Justice Kennedy as the swing vote. If there's a decision for Fisher, it will almost certainly be a 5-3 with Kennedy on the top of that decision.
All right, Mr. Batterman, do you agree with that assessment?
I definitely agree with that. I think it'll be interesting to see if the counselors specifically tailor their arguments to Justice Kennedy, and it's also possible that some of the other justices will try to help the counselors tailor their arguments to Justice Kennedy. I think he's the clear swing vote. Okay.
All right. Now, that is, as Ms. Berthume said, in the real Fisher versus University of Texas case, there's only going to be 8 justices, as Mr. Linda Kagan has recused herself because she worked on the case before she got to the court. Now, because this is a simulated fashion, we actually are going to have a student played the role of Justice Kagan, but will take no part in the actual voting for the verdict. But you will see Ms. Kagan on the court. Now, it seems to me that the justices are ready to proceed. So once again, we'll have the two verdicts based upon the arguments that were made yesterday, and then we'll move directly into the arguments for the Fisher versus University of Texas case. Thank you very much for watching WA Live Court TV. We're going to turn it now back to the courtroom and watch as the justices enter into the courtroom to begin the proceedings. Thank you.
All rise. The United States Supreme Court is now back in session. The Honorable United States Supreme Court Justice is presiding.
First on the agenda is a decision that the court has reached in the matter of Florida versus Jardines. The court rules by a vote of 5-4 in favor of Florida. Second, in the matter of Florida versus Harris, the court rules by a vote of 5-4 for Harris. Next up, we will hear arguments in the case of Fisher versus Texas. Is the attorney for Fisher ready to proceed? You may proceed.
I'm Jack Fleming, representing Abigail Fisher in the case of Fisher versus the University of Texas. This case involves the issue of whether or not the 14th Amendment is violated when a university uses race as a factor during the admissions process. Abigail Fisher was an applicant to the University of Texas in 2008. Because she was not entitled to the automatic admission under Texas's top 10% law, she instead applied as a non-top 10% in-state. Here, she was competing against others for admission to the university. Among the applicants in the non-top 10%, she exceeded many of the minority applicants in test and SAT scores, so her objective credentials were better. Fisher had a strong 3.59 GPA and was number 82 out of her 674-person class, according to the Houston Chronicle. This would put her not far from the top 10%, which would put her automatically into UT. On top of her academics, Fisher also played soccer throughout high school and did volunteer work. However, she ended up not being accepted into the university and sued the university on the basis that it had violated her 14th Amendment right of equal protection. She found out that other minority applicants had been accepted into the school, even though her credentials were better than them. The University of Texas considers various factors during its admissions process for those in-state applicants in the non-top 10%. The university reviews all of its applicants on the Academic Index and the Personal Achievement Index. These are based on standardized test scores and high school class rank, and also focus on the strength of their application essays and the extracurricular work or extracurricular activities in which they have engaged. Also included in the decision process are the special circumstances of the applicant, such as socioeconomic status, family status, and race. Thus, UT's current admissions system expressly considers race for admissions and placement. After being denied admission into the university, Fisher filed suit in the United States District Court for the Western District of Texas. The District Court granted summary judgment for UT, and the Fifth Court affirmed, seeing that UT had stayed within the boundaries of what the recent Supreme Court case, Greta versus Bollinger, had ruled as acceptable factors for consideration of race during the admissions process. The ruling in Greta versus Bollinger was that universities may take race as one factor into consideration for admission, along with many other factors when selecting applicants. The Supreme Court ruled that race may be one factor and may not be the deciding factor for an applicant.
What is your argument that race is the deciding factor in this case?
Well, wait, could you please restate the question?
Yes, you say that race can be a factor, but it cannot be the deciding factor. What is your client, Abigail Fisher, what is her evidence that race was the deciding
she had better
factor?
credentials than some of the other applicants that made it into the school, but some of the other applicants were minorities, so my client believes that they had a better chance of making it into the university because of their race.
Does the university say they use race as part of the decision process?
Yes.
You said there is a 10% rule, you have to score in the top 10% in order to...
Yes, the top 10% from high schools automatically make it into UC.
So what percent was she in?
She was just outside the top 10%. She was like around 11%.
So does she know, were there any people of a minority that were in the top 10% that were, well, maybe just right outside the top 10% as she was that were admitted?
I don't know, but I know she had better credentials than some of them who didn't make it in.
How did she find out that some of the people's credentials weren't as good as hers?
I don't know that.
By better credentials, can you specify?
I mean, test scores, SAT scores, and extracurricular activities.
So you believe that she was much better in terms of those?
I mean, not much better, but better than some of them.
So her credentials were not substantially better than some of the minorities that got in?
I'm not sure if it's substantially, no, but...
But she seemed more qualified.
Yes, she did seem more qualified in those.
Is it your understanding that under the University of Texas policy that a minority candidate with better scores and grades than Abigail Fisher may also not have been admitted to the University of Texas? Is that possible?
Yes, Your Honor.
So does your client not believe that since she scored outside of the top 10%, that could be a possibility of why she was not admitted into the school?
Yes, but her credentials were just as good, if not better, than all the other applicants.
Do you know for a fact that there were that Abigail's credentials were better than any minority outside of the top 10% who was not admitted?
No, but she was very close to top 10%.
Can you provide any examples of certain credentials or scores that got in that were not as good as hers?
No. For people like Abigail Fisher, consideration of race in the admissions process hurts their chances of getting into a university that they would like to attend. The University of Texas argues that consideration of race, along with all the other factors for admission, is important and creates a diverse.
What is the majority population of the school? Like, what is the majority race of the school?
I don't know.
But would you say that the school is more minority or more Caucasian, or what would you say?
I would assume it's pretty diverse. I don't know.
So there was an equal number of Caucasians than there was to minorities.
I don't know the numbers. And is beneficial for the student body. Affirmative action may have served a purpose in the past, but is it really fair today and needed for a university that is supposed to be educating people and should not be worrying about what the racial makeup of its student body looks like? But it is true that part of education is learning and being around different cultures. This does not mean that minorities should be denied admission into schools and that students should not be subjected to different cultures, but there must be trust that minorities will still be admitted into schools. Furthermore, my client believes that having race as a factor in admissions also results in denying admission to applicants who are worthy of attending a certain university. This case specifically addresses the 14th Amendment's Equal Protection Clause. The Equal Protection Clause states that no state shall deny any person within its jurisdiction equal protection of the laws. All citizens should get equal rights within their state, and a public university should have no right to determine whether applicants are admitted or denied admission into a college where the objective is education based on race. If no citizen can be denied equal protection based on race, then the question becomes whether or not race should be used in an admissions process. Even though Greta versus Bollinger ruled that it was acceptable to use race as one factor, it did not say that race could be a dominant factor in choosing applicants for admission. And Greta versus Bollinger also recognized that affirmative action should not last forever. In our case, UT did not allow an applicant into its school even though she exceeded credentials of her minority peers against whom she competed. UT and other universities where race is a factor in the admissions process should not be allowed to discriminate based on race. My client, Abigail Fisher, clearly deserved admission into the University of Texas. Unfortunately, the fact that race is a part of its admissions process into the university is a huge reason she was denied. The university could see that she had strong credentials with a good GPA and engaged in extracurricular activities, but she did not get a chance because of affirmative action in universities. Minorities get the upper hand during the admissions process and essentially get a better chance of being admitted into a university. If the Supreme Court does not overrule Greta versus Bollinger and race continues to be a factor in deciding whether or not young adults get the opportunity to attend a university of their choice, there will be more situations like this where a perfectly worthy student that is not a minority gets denied admission. The Constitution prohibits states discriminating on the basis of race, and it is important that this prohibition is enforced to protect citizens of all races. If the Supreme Court truly wants universities to not discriminate on the basis of race, then they need to rule that universities should stop discriminating on the basis of race.
The attorney for Texas.
Yes, sir.
You may approach the podium. You have the court's attention.
Hello, my name is Tam Wheat, and I will be representing the University of Texas in the Supreme Court case, Fisher versus the University of Texas. Allegedly, a student by the name of Abigail Fisher has been discriminated against and not admitted into the University of Texas based on the basis of positive discrimination. Allegedly, her test scores and GPA average excelled, although slightly, beyond certain peers that she believes gains acceptance based on their race. The University of Texas appeals to the fact that the individuals who were admitted were judged on a variety of other criteria besides just their race, and there was no racial bias against Fisher, but rather a wider acceptance of diversity onto their campus. And her colored peers may have gained admittance based on many other reasons.
What are the reasons?
Extracurricular activities, socioeconomic standings, family circumstances, leadership qualities, talents, hobbies, etc.
How would you measure leadership qualities?
You would probably have to see which clubs or extracurricular type of activities the student participated in.
Did Abigail play soccer?
It is alleged that she did.
Were there any other students of the same race as Abigail who were rejected with similar credentials?
Yes, there was. In fact, another student who filed suit was Rachel Michaelwitz, but she dropped her case in 2011. She believed basically the same that Abigail Fisher did, and that she was discriminated against because she was Caucasian.
At what point does the University of Texas consider a candidate's race?
They consider a candidate's race when they are deciding out of the non-top 10% because they have the top 10% rule, and they 81% of the freshman class in 2008 got in by the top 10%, and she was in the top 12%.
What is the University of Texas's interest in considering race?
Their interest in considering race is that, well, one, it is constitutionally required by the Greta versus Bollinger case, and that they believe that it will spread diversity on their campus and allow for the minorities not to be discriminated against.
So at what point does the University of Texas know that they are diverse enough?
Well, there cannot be quotas for the amount of minorities that are admitted, but there has to be what I assume they would believe would qualify for a diversified campus.
So how
How
do
would
they
you measure
determine what to believe?
How would you measure that?
They determine that most likely by the students outside of the top 10% who are minorities but also have other qualities about them.
So are you looking for a particular number?
No, there are not quotas.
So
This-
would you say that there's an equal amount of Caucasians and minorities on campus?
That is unknown, but it is likely that there are more Caucasians, as there are more Caucasians in the United States.
So in the 19% of the students that you admit who are outside of the top 10% of their class, of that 19%, would it be acceptable to the University of Texas to have 0% minorities?
I assume that would depend on how many minorities, well, not really number, but they just try to find the students, regardless, who are most qualified to get into their campus.
But Ms. Fisher's allegations is that she is more qualified.
Her qualifications were not extremely impressive. Her GPA was a 3.59. I believe her SAT scores landed her in the top 60%.
But she's not competing with the 81%. She's competing with the 19%.
She's competing with the
So relative
19%.
to the 19%,
She was very competitive.
what did not qualify her, right?
She had shown minimal extracurricular activity. Her
How
scores.
do you determine minimal versus, like an extreme amount?
It would depend on the personal opinion of those in the admissions board.
What was the minimum GPA in order to be accepted into the University of Texas?
There was not a minimum
Do you
GPA.
know the lowest that was accepted?
That is unknown.
Do you know average GPA that most students had at UT?
That is unknown.
Do you know how many extracurricular activities other students should have participated in that did get admitted?
That is unknown.
Do you know the average SAT score?
That is unknown.
Going back to something you said earlier, you said the court case that set precedent to this said they are required to use race as a factor, or they may use race as a factor. You said required.
Yes, I was incorrect. They may use race, and the
So
University
they
of
don't have
Texas. Yes, the University of Texas in the 2008 freshman class decided to use race.
Is there anything in the Constitution that would compel the University of Texas to consider race?
The Greta versus Bollinger case.
That doesn't compel them. That just allows them to. Give them a reason.
What would compel them would be probably minorities who had been complaining about the lack of minorities in the University of Texas. Again, I had said that Michael Witz has dropped her case. This case, honestly, has lost relevance. It should be ruled that Greta versus Bollinger is constitutional. It has been, affirmative action has been used as a base for college admissions. Affirmative action exists because without it, races such as Latinos and blacks would not receive equal rights and opportunities as the Caucasians. The discrimination against Caucasians that exists currently, if any, is so minuscule and trivial compared to the discrimination that would arise if affirmative action was overturned. The system as it is provides the most equal and just opportunity for everyone, and if it would change, there would be an unfair advantage for majority races. It would be preposterous to do away with affirmative action. Fisher was not allowed into university based on a variety of different considerations. It is believed that she chose discrimination because she saw ethnicity and minorities as an easy target, as she had been able to observe from the past. She seized the opportunity and came to attack the whole system and expunge affirmative action.
What other universities did Fisher apply to?
Hold on. Fisher, well, that is unknown in 2008, but she attended a university, I can't find it right here, but she attended a university that was ranked around 140, and
Did
Texas.
She attend LSU?
Yes, LSU. Thank you. She attended LSU, and Texas at this time ranked around 40, based on the United States Texas college United States college rankings list. Her GPA was not as outstanding. Again, she did not display the qualities that the campus was looking for. Fisher filed suit against the University of Texas because society has pushed her to and encouraged her to speak out against the government based solely on the cause that she had not received what she had wanted. Many parallels can be drawn between Fisher and Veruca Salt from Willy Wonka and the Chocolate Factory, because when they did not believe what they had earned, despite not earning it, they believed that it should have just been handed to them. There are innumerable reasons why Fisher should not have been admitted into the university, and affirmative action is not the sole reason to blame, if the reason to blame at all. Fisher should take blame for her responsibilities because there's no reasonable evidence as to why the Grutter versus Bollinger case should be overturned.
Did Fisher have any record of trouble in high school, or
That is unknown.
did she have a criminal record at all? Or
It is unknown.
Attorney for Abigail Fisher, you have an opportunity for rebuttal. Do you wish to, would you like to exercise this opportunity for rebuttal, or would you like to waive your rebuttal? Thank you, counselors. We will take this case under advisement. The United States Supreme Court is now adjourned.
All rise.
Welcome back to WA Live Court TV. You heard the arguments made by the lawyers to the judges, and I promised you earlier in the week that we're going to have a special guest with us here live in the studio, and that special guest is going to be Marcia Spiller. Ms. Spiller, will you please come and join me at the Court TV table? Welcome.
Thank you, Brian. Good to see you.
Nice to see you. All right. as I said, today we have a special guest. We have Vice President Spiller, and she's going to talk to us a little bit about the arguments that the students made and a little bit about the policy of affirmative action, etc. All right. Now, you've been here at Woodward for about a year, have you not?
Almost a year.
Almost a year. Well, how do you like the Woodward Academy so far?
I love it. It's a great place to work, and I'm really enjoying being here.
All right. Very good. As I understand, you were the former head of the children's school in Midtown Atlanta. Was that for, what, more than 20 years or so?
22 years, yes.
22 years.
Yes.
Wow. All right. Now, as I also understand, Vice President Spiller, you are the former chair of the board of the National Association of Independent Schools, otherwise known as the NAIS.
That's correct.
Will you please tell your audience who may be unfamiliar with the NAIS what your role was and what their mission is?
Well, National Association of Independent Schools represents about 1,700 independent schools in the United States and the world. And it is the national organization that advocates for independence in those schools. So each school is able to have its own mission, follow its own mission, and be supported by that national organization.
Okay. All right. Now, tell us, what do you see as some of the issues facing secondary schools with respect to diversity education?
Well, this is an interesting case, and I think that schools now are working on being welcoming and inclusive learning environments for all kinds of students. And I think that this case probably speaks to that in some way.
All right. Now, do you believe that the Woodward Academy or other members of the National Association of Independent Schools should be required to use race as a factor or be allowed to use race as a factor in admission as a way to achieve racial diversity on campus?
I think that individual schools should be allowed to use their own policies, and if they would like to include race as something that they want to look at in terms of their applicant pool, I think that they should be allowed to do that. I would not require someone to do that, but I certainly think it should be allowed. Many schools are very interested in having diverse populations among their student body because they feel like that's a better learning environment for all of their students.
Right.
And so schools should certainly be allowed to do that if they see that as an important part of their own mission.
Okay. Now let's talk more specifically about the case you heard today. Tell us, give us your impressions regarding the students' arguments in the Fisher versus UT case.
Well, I thought they did a good job of researching the case, and they certainly represented their sides very well. They had they've done their homework, and the attorney for Fisher was very well prepared. The attorney for the university was very well prepared, and while they could not answer some of the specific questions from the judges, I think that they knew their case and did a good job representing.
Okay. Now, Vice President Spiller, as you know, we try to get Stephen Leslie, the provost for the University of Texas, here today. He declined, citing some pending litigation at the moment. But we're glad that you are here to join us in the studio here at WA Live Court TV. Since we don't have Provost Leslie here, I'm going to ask you the questions I would have asked him if he were here. And the question I'm going to ask you is, hypothetically, let's consider if the Supreme Court rules in favor of Ms. Fisher and states that the University of Texas may not use race as a factor in an admission process. What effect, if any, do you think that would have on the goals of diversity on college campuses and campuses everywhere else?
Well, it's going to require the colleges and universities to come up with another system and another process to ensure that they have diverse applicant pools and eventually a diverse population on their campuses.
And what would that look like in your opinion, if you know, if you have one?
I don't really know I don't know what the policy would look like, and I think for different schools it might look differently. For example, a school that may have a religious philosophy to their school may go about it a little differently than a school that doesn't.
Right.
So I think that really it's going to require them to do some work, again, looking at their own mission and their own purpose as to how they're going to be able to diversify those applicant pools.
Okay, now, essentially the exact same question, but let's hypothetically assume that the the Supreme Court rules in favor of the University of Texas and says that college universities across America may still use race as a factor. What do you believe, what impact, if any, do you think that would have on diversity education in America?
Well, I think that would allow colleges and universities to be able to sustain diverse populations, and I think that that's really what the Bollinger ruling was all about, is being able to provide a diverse learning environment for all students, and that apparently was important in that particular case to that particular school. So I really think that if the court decides to rule in favor of the University of Texas, what it's saying is that you may use race, you are allowed to, but not required to, in your admissions process.
All right, well, that's the last of the questions I have for you, and I want to thank you for joining us here at WA Live Court TV. Now, seeing that we only have one more minute before the next bell rings, and it seems as though the U.S. Supreme Court is going to come back into the courtroom and tell us what their particular verdict is on the Fisher versus UT case. Thank you very much for watching WA Live Court TV, and we're going to turn it back to the courtroom for the verdict.
All rise. The United States Supreme Court is now back in session. The Honorable United States Supreme Court Justice is presiding.
In the case of Fisher versus University of Texas, it weighed heavily on the court that we were being asked to overturn long-standing precedents, notably Grutter versus Bollinger. However, by a 5-4 vote, the court rules in the favor of University of Texas. The court is adjourned.